Great. So thank you so much for the invitation. Today I'm going to talk about the promise of AI to help achieve a more just system. In the first half, illustrating with our ongoing work at the Judicial program, Data and Evidence for Justice Reform. And in the second half, stepping back with a theory of change underlying the interventions. So I'm trained as a lawyer and as an economist, and I have an early background in computer science. The other leads at the World Bank, Manuel and Sandeep, also have a similar background. Manuel in economics and law, and Sandeep a math PhD with an interest in data science. So our broad framework is to work with government's judiciary's administrative data, interest in machine learning, and randomized control trials to evaluate the effects of justice reforms, with a sideline towards increasing efficiency and fairness of law to meet sustainable development goals. As we know, there's a strong association between economic development and rule of law. But what can we do to improve the rule of law? So here's a map of the countries we've worked in so far. These tend to be grouped into 3 categories. In the first group, Chile, Peru, and to a lesser extent, Kenya and Pakistan, we work closely with court management, judiciaries, and training academies to design, deploy, and evaluate interventions, often developing the technologies to do so. In the second group, Brazil, Czech Republic, and recently India, we work with auxiliary actors involved in access to justice, legal search engines, legal analytics to assess trustworthy AI and its effects, or prisons to assess trust in the law and its effects. In the third group, where India started, or Croatia, we've obtained the data, often laboriously, and make historical analyses on judicial efficiency or inconsistencies that may hopefully spur a cycle of change. For instance, the Indian Supreme Court Justice recently gave a talk to the World Bank where he discussed data interoperability, public-facing dashboards, data integration, much of which overlaps with our efforts over the last 2 years. Now, the reason we can do this is the confluence of 2 factors: the shift from paper trails to digital ecosystems at a large scale, and the advent of machine learning tools that can create interpretable data from unstructured data, even predictive models of decision makers to better understand their inconsistencies and now address them with digital interfaces. For instance, in Chile, we work with the court management to personalize nudges for judges and court admin, showing them statistics that they're worst performing on, what they're most improved on, to see if this motivates actors who tend to have fixed salaries or life tenure, and to give a sense of our dialogue where we listen, brainstorm, and propose. We initially drafted these as nudges that appear at the top of the screen. Our counterparts got so excited, they've made it mandatory, filling up the screen before they could click through. In Kenya, we have an earlier project that also displays recommendations for how they can improve a deficient statistic. That is, we give them advice on how to improve. And this is part of a lending agreement on judicial performance improvement. The Chief Justice had gone on the record to say, endless adjournments of cases on frivolous grounds are a major cause of case backlog. So as part of the lending agreement, Kenya created the first digitized daily court records, and we grafted on a nationwide experiment, developing an algorithm to identify the greatest source of court delays. So in one treatment, we provided actionable information, that is, these sources of court delays. In the second treatment, we provided information and accountability. So the one-pager on the previous slide was also shown to the court user committees who could potentially deliberate about this information. And in the control group, they received the status quo, so no information. And this was randomized across all 124 court stations. The information provided was data-driven. So using the newly digitized court records, the greatest predictors of adjournments were presented in this one-pager in a descriptive, interpretable sentence. Addressing X would increase case clearance rates by Y amount. And we found that information and accountability reduced adjournments, especially those initiated by the judge in column 2, and no effect on those initiated externally by the litigants in column 3. And this will shortly become monthly. Now, the effect size of 3% are large relative to a baseline of 18%. However, the advice is top-down, based on data already collected, using data fields previously designed by the computer coders for individuals to express a reason. So can we help countries develop the institutions to generate their own better policies? A model of some at the World Bank. So in Peru, we literally asked them to give advice to someone like themselves, which recent research has documented can improve intrinsic motivations, empathy, a sense of social identity with the occupation. And then we randomly assign the advice for others to read so we can see its effects on decisions and disparities. And to give a sense of how this conversation developed, they initially approached us to evaluate the effects of a shift from theory to case-based teaching, a moment that characterizes legal education across many countries in the last century. So we suggested in this moment with machine learning tools, what about personalized case-based teaching, using the history of their decisions so they can self-reflect. So they mentioned these self-reflection writing exercises about what the judges wanted to get out of the class. And so we proposed these social emotional learning interventions. And so as in Chile, they got so excited, they've essentially made these highly encouraged. So we have almost every student, judge, and prosecutor doing these treatment and control treatment writing exercises. And so we can assess its effects on decisions and disparities. Now, building on the success, we formalized the advice giving that happens around water coolers, bulletin boards, and conferences with the following app. So conciliation and mediation are a huge part of the legal ecosystem in many developing countries. So we initially designed these as an app for the managers to see the conciliator's performance, to explore the data for patterns in different ways, or on the upper left, download reports for emailing the conciliators. So let me see if I can switch my screen and demo the app. So you can see for this dashboard, say the manager wants to ask, are the legal centers that take longer in handling cases, paying more attention, and so having a higher success rate? Actually, you see the opposite, those that spend more time are actually less successful. But maybe it's another determinant. Maybe it's caseload or the number of cases that are driving success rate. And they could change the timeline. They can send reports to their conciliators. They can explore this geospatially, or they can also drill down into certain case types or compare conciliators pairwise. And so the dashboard lets us observe the regressions that they run. Let me switch back to the other screen. That is the potential causal hypotheses they wish to explore. Or in Kenya, they've requested support in assigning mediators to cases. So which we proposed as a motor-armed bandit. So the idea is that certain mediators might be generally more successful in certain types of cases. So consider an adaptive learning framework for optimal specialization. We've also expressed an interest in how to motivate the mediators. Now, to some extent, both of these questions assume that the mediators are fixed inputs or fixed functions, but maybe they're malleable. An insight we've learned from studies on growth mindset or non-cognitive development. So we've also proposed in the conciliator app, it takes a little too much time to switch screens, but I hope you get the idea from the first demo, that we can ask conciliators that are the top performing on any indicator to give advice that can be randomized to other conciliators, which dynamically generates an automated policy causal inference machine that is help countries build institutions to develop their own better policies. And so like the other dialogues, the counterparts get excited, they now push the data to us. Often we do the same with the other data ecosystems, victims defense, public defenders, psychological support. So we even offered an API for them to upload and create their own dashboards as they update the data. So we also ran into the issue in Peru where logs and data were not necessarily being entered regularly. So we designed an incentive system for keeping logs. So there's another login for conciliators to see summary statistics of themselves, or there's a prototype with the ability to log, for example, a monthly diary to describe the strategies they deem successful. So the idea would be to build off the Kenya RCT or the advice-giving framework of social and emotional learning. They give advice to literally themselves in the future. And we can record and present the correlates of improvement. That is transfer learning both across and within decision makers. We've also proposed wiki surveys so the conciliators can provide structured questions for more successful conciliators so they don't get responses like be more compassionate. And these projects are built with open source code and are part of a 5-year loan agreement that includes evaluations of legal aid, judicial training, and electronic processing. Now, ejustice is thought to improve efficiency and access. And we can think of these interventions as testing the mechanisms behind the framework, which I'm going to describe, this more of a theoretically founded incremental AI or human in the loop move that computer science has advocated in recent years. So we can think of at least 3 uses of judicial analytics. So this is where I mean machine learning and trying to understand and predict judicial decisions. Predictive analytics of judges can help in scoring judges, measuring their productivity in innovative ways. Predictive analytics can be used for causal inference, automated prospective impact analyses of their decisions, and predictive analytics can help increase recognition of dignity. We can think of this as developing institutions to help individuals be their best self. So cognitive science and psychology suggests that humans have limited and imperfect reasoning capacities. Judges are human, and they're influenced by the weather. Judges deny refugees asylum when the weather is too hot or too cold. The time of day. They grant asylum more before lunch and less after. Defendant's name. They assign longer sentence lengths to defendants whose first initials match their own. The defendant's birthday, when they do the opposite and give the gift of leniency. NFL football. Judges are more lenient the day after their team wins rather than loses. Snap judgments. We can use machine learning to predict asylum decisions with roughly 80% accuracy the date the case opens and when it closes. Elections and wartime also affect decisions. But not only, there's the gambler's fallacy, a well-documented tendency for people to misperceive random sequences. So in a sequence of coin flips, it's not that uncommon to have streaks of 1s or streaks of 0s. In other words, any 2 sequences are equally likely, but people tend to think the sequence at the top with rapid alternations is more likely than the one at the bottom. So if I'm an asylum judge and I have the gambler's fallacy, and I grant asylum too much in a row, I might worry I've become too lenient. If I deny asylum too much in a row, I might worry I've become too harsh. So I might actively negatively autocorrelate and just trying to be what I think is a fair and just judge. And up to 5% of decisions are reversed due to the gambler's fallacy. In the US Supreme Court, the first sentence of the lawyer's oral arguments are identical. Mr. Chief Justice, and may it please the court. So we clipped these sentences and asked human subjects to rate the voices on masculinity, intelligence, trustworthiness, characteristics that previous research deemed relevant in social settings. And it turned out that male petitioners below median in masculinity rating are 7 percentage points more likely to win. Now, besides the voice, there is text. So we can train an embeddings model on the corpus of US judicial texts in the appellate courts, going back to 1891. And we can see on the left that the female vector is associated with migraine, hysterical, morbid, obese, terrified, unemancipated, and battered. And on the right, the male dimensions associated with reserve, industrial, honorable, commanding, conscientious, and duty. So we can do this judge by judge, and we can see that Justice Scalia is an outlier in gender slant. And in the circuit courts, where judges are randomly assigned, judges with more gender slant vote against women's rights issues, assign fewer opinions for females to author, cite female judges less often, and reverse male judges less often. So we find a number of behavioral factors associated with judges' verdicts, but another element appears very important. By 1990, 40% of federal judges had attended an economics training program. This law and economics training program was founded in 1976 as a 2-week training course with lectures by Nobel Prize economists Milton Friedman, Paul Samuelson, and many other luminaries. We obtained a list of all the attendees from an article written by a former director. This article also had letters written by judges expressing how much they learned, how much they felt they'd become a better judge. And the results of these seminars were dramatic. We can see economics language used in economics articles become prevalent in opinions. We can see economics trained judges changing how they decided and impacting their peers. We can see economics language traveling from one judge to another and across legal cases. Economics likely changed how they perceived the consequences of their decisions. In economics cases, judges shifted by 10% the direction of their votes. So if you teach judges that markets work, then they'll vote to deregulate government. If you teach judges that deterrence works, they'll become harsher to criminal defendants. In the district courts, when judges were given discretion in sentencing, economics trained judges immediately rendered 20% longer sentence lengths relative to their non-economics counterparts. Now, part of what made economics training so successful is likely because theory provided structure for judges to understand the patterns that they saw. But maybe we can go farther. If judges are shown their behavioral findings, will they become less prone to behavioral bias? If judges are taught the theoretical structure that drives the behavioral bias, will they become better judges? Will better justice increase cooperation, trust, recognition, and respect? One possible framing is a definition of justice as equal treatment before the law and equality based on recognition of difference. Using the language of machine learning, we can think of a set of X's that should lead to the same predictions or predictability of outcomes. The X's should improve the predictions, and a set of W's that should not. We tend to think of the X's as consequences of our actions based off of the control principle and the merit principle, that we should be blamed only for events under our control. And W's might be race, gender, expressions of our identity, but also events outside of our control like football, weather, the judge's lunchtime, or preceding case. So behavioral anomalies offer an intuitive understanding of future relevance. Psychologists have documented many effects only of moderate size in the lab. So settings where judges are closer to indifference between options are more likely to lead to detectable effects of behavioral bias outside the lab. So let's suppose this parabola captures what the judge thinks is the right sentence. Small deviations cost little. The judge isn't sent to jail. Now suppose the parabola flattens. 8 months, 8 years. I don't care. I'm indifferent. Then as my preferences over the legally relevant factors wanes, the influence of extraneous factors grows. So we can think of measuring behavioral anomalies as documenting revealed preference and difference. So what can AI do about this? So policy discussions tend to revolve around having AI replace humans or suggest the optimal decision. But consider instead an incremental approach that shows decision makers their predicted self and then uses predictions of errors to nudge. So in stage one, you might think of a recommender system that offers decision makers the best predictions of themselves using their past decisions, the history of the past cases, and using only the legally relevant features X's. So we'd begin by assessing the human judge with the predicted self to see if there's even room for improvement. So if I'm very behavioral, I'm very distracted, cognitively disengaged, then you might think that the predicted self will do better than the human self. But instead, I'm very attentive, paying attention to lots of important features that actually aren't included in your machine learning model, then the human will do better than the predicted self. But showing the predicted self has at least three purposes. We can provide an anchor, giving them a relevant reference point, helping them compare apples and apples, oranges and oranges. It's an anchor they can deviate from, which facilitates more conscious deliberation. And then seeing the predicted self leverages what some theorists have called self-image motives that are suggested to motivate pro-social decision makers like judges. In the second stage, we might use all the X's and W's and see if a deviation from the default is predicted to lead to error, in which case you might accompany this deviation with a nudge to pay more attention, to spend more time in the case. And notice it's a nudge, it's not a long checklist, so we're going to impose less bandwidth, conserving time and energy to focus on more novel and complex cases. In stage three, we can use the AI as a coach, providing feedback on choices. So a decision maker might want interpretable machine learning, request a reason for why the deviation might lead to mistakes. And research has shown that the more people feel that their autonomy is protected, that they're in control of the conversation, that they're able to choose when feedback is given, the better they respond to this feedback. In stage four, we can allow a dialogue. It's always possible the AI doesn't have the private information that the decision maker has access to. In this case, the AI is possibly steering the decision maker off course rather than correcting for inconsistencies. So you can allow the AI to learn from the user by having the decision maker explain the changed circumstances. In stage five, you have a community of experts. So once you can create a prediction of a self, you can create predictions of many of the other decision makers. And you can have this be accessible as a drop-down menu so you can seek advice from a specific decision maker, or maybe a statistical distribution to protect privacy. So there are other stages, and in interest of time, I'll just highlight, for example, we might use this to train novices, use this to increase transparency or accountability, or use the changed circumstances, the dialogue, and feed it to other judges in an A/B manner to generate personalized causal inference. So these address common criticisms of AI in law. We reduce bias, we increase autonomy, we enhance learning, we have explainable, transparent machine learning, and we incorporate private information that change circumstances. So I won't have time to talk about other ways for machine learning to diagnose judicial inattention that might serve as foundations of new indicators for objectiveness in enforcing regulations. So besides early predictability and behavioral anomalies that I already described, inattentiveness, whether their implicit risk rankings are closer to random, or are they flipping a coin? Is the indifference greater for certain groups? And then let me just end on this final slide on how AI could also be used for automated prospective causal inference analysis. So in medicine, prior to clinical trials, doctors theorized about the effects of decisions. There was no causal evidence. In law, as we're taught in law school, it's often the same way. We can't randomize judicial decisions as it violates the notions of justice and equal treatment for the law. But randomizing judicial assignment generates a retrospective clinical trial The first paper illustrating the approach was only published in 2006, and there have been many more since the credibility revolution in economics. And so the idea is that you might use the fact that a litigant was assigned to a judge that's predicted to be harsh or predicted to be lenient, and see what are the long run impacts of being assigned to a predicted to be harsh or predicted to be lenient judge, and their family members and their coworkers and all the other downstream consequences that might be of interest. But the research is evolving as we start thinking about the text of judicial opinions, the high dimensional treatments that any opinion might actually be reflecting.